Welcome and thank you for joining us today. Our CU session is titled Elections for Community Associations, Best Practices, Legal Requirements, and How to Run a Clean, Fair, and Transparent Election Season. If you guys could hear me, go ahead in the chat. Just say, I can hear you. Your time is extremely valuable to us today, and we appreciate you joining us with the intention to lead your communities, or even just to get information to help you out if you're a community association manager. Let me introduce myself real quick. My name is Michael Manrique. I'm the Director of Business Development and Marketing for Affinity Management Services, and I'll be your host today. We're honored, so honored, to be joined by attorney Emily Gannon. That's right, Emily Gannon. The crowd goes wild. I know we can't hear you guys, but everyone is cheering. Who brings extensive experience in community association governance, elections, and compliance. Emily has been leading the majority, or will be leading the majority of today's educational content. Before we get started, all right, you'll see a link in the chat to join our Affinity Management Facebook group, where board members share ideas, ask questions, and can continue to learn beyond today's lesson. So I encourage you to click that and sign up. We'll leave that in the chat. I can hear you. Awesome. Great to hear, Claudia. Thank you very much. And then we're going to wait. We see people are still entering the room. So just to wait, as we're waiting for this meeting to begin, I'm going to ask a question. So how long have you either been a community association manager or a board member, and what city are you joining us from today? So go ahead and respond. How long have you been a board member, and what city are you joining us from today? Wow, 15 years, Tampa. Awesome, Paula.
I wish we could say there was like a prize for the farthest location or something, but
we could say
it's
it.
just more fun.
Get it. I don't know if they'll get the prize though.
Yeah, right. Prizes, we will say your name on air.
Awesome. 8 years. Wow, we got North Carolina in the house. Awesome. Wow. We got Florida since 2023. All right, born St. Lucie. 8 years. It looks like 15 years from Tampa. Paul's taking the lead. Anyone else? Anyone more than 15 years? But we appreciate everyone else that's attending, providing us that information. We still got people coming in. Whoa, Cam for 18 years, Miami. Great job. All right, 6 years. All right, so I think that's enough time. So that we should be dropping that link for the Facebook group. It should be coming in here soon in the chat. You guys could click that when you're doing your free time. But we're here for Emily. That's right. So Emily, why don't you go ahead and take it away?
All right. I'm seeing comments that there's no video. Is that okay, or is it just because I haven't shared my screen yet? Just making sure
They should.
I'm not great with tech, guys. I'll tell you. I'll be honest here.
Okay, no video here. Take participants. Okay, go ahead. Try sharing your screen.
All right. So let's.
I know I just took.
Let me share my.
We got one person saying video works. Jane.
Okay.
But most people say no video. Claudio, 17 years. Awesome. All right. Matthew says his video is working. Look at that. I removed myself from the camera and now it starts working. That's funny.
Were you the jinx?
I think so.
All right.
All right. Can everyone see the slides?
Okay. Oh, goodness.
All right. Terry said good. Video working.
Did I open the wrong?
All right. So they can see the slides.
Hold on. I think I somehow have the wrong. Hold on. Let's see. Did I link the wrong one? Hold on. I don't know why it's doing that. Sorry, guys. Like I said, I am not the most tech savvy. It's open on my end. I don't know why I can't get it to share correctly. Hold on. Right. Well, to give you a little background while I'm doing this, my name's Emily Gannon. I'm here from Kaye Bender Rembaum. All we do is association work. So we are based I'm in the Pompano office, but we cover basically all over the state at this point. We have a Broward office, a Palm Beach Gardens office, Miami offices by request. And then also we have an Orlando office and a Tampa office. So we pretty much cover almost everywhere in the state. And all we do is association work. And for some reason, I can't get these slides to open. Hold on.
Right. So actually, I just noticed I forgot to mention something. So before we jump into the content that Emily's putting together, let me walk you through today's CEU requirements and what to expect. So the evaluation form is required to receive your CEU credit.
Oh, yes.
So we'll be sharing that link toward the end of today's webinar. So it's really important. You'll find that in this chat. So this meeting chat is where it'll be dropped, where you guys are typing right now. So I'll be dropped in the chat. It's very important that you stay throughout the entire meeting, okay? KBR will email you the CEU certificates to everyone who attends in full, okay? Let me say that again.
Yes.
It's who attends in full will get credit for their CEU for this specific course. They asked to please allow 5 to 7 days from today to receive that email. And then let's see here. As far as questions. Oh, did you do something there?
I do not know.
Oh, okay. So one thing that's also very important here, 37 years. Wow, who is that? Totally missed that. Claudia, thank you for bringing that up. I totally missed that. I apologize. Whoever has 37 years as a CAM, congratulations to you. But let's talk about the format. So the way this is going to work is I want you guys to drop your questions once Emily gets going in the chat, but we're not going to address them to the very end, okay? So just go ahead and drop the questions, and then I just want everyone to be on the same page. Emily's going to do her thing. We're going to get through all the slides, the education, and then we're going to come back to those questions, and we'll touch them one at a time at the very end, all right?
We're starting with annual meetings, elections. That's what we're talking about. First things to think about when we're talking about your annual meeting and your election is how many directors are on the board. How many directors are we electing? What's the story? So first you have to look at your governing documents. Typically it's going to be in your articles or your bylaws. When we say governing documents, we really mean sort of the whole body of documents that control your or that govern your association. That includes your declaration, your articles of incorporation, and your bylaws. Most of the stuff for your annual meeting and your elections is going to be contained in your articles and your bylaws. Those are the documents that set you up with the state as a corporate entity. That's what gives you gives you all of your guidance in terms of sort of your operations and meeting notices, things like that, those details. That's all going to be there. So articles and bylaws are going to be really important for this conversation today. I know there are no slides, guys. We're having some technical difficulties, so you're just gonna have to listen to me for a minute. And hopefully, again, Michael can figure this out for me, or Dulce. So, how do we know how many directors we're going to be electing? First thing is really going to be there we go. So you look there. That's where we start. Look in your governing documents, and then if we don't have an actual number, if we don't have we're on slide number 4, just so you know. There we go. Okay. Now, is there a way for me to scroll through these slides? That's the question.
You're going to have to just tell me.
Okay. All right. Sorry. All right. So really, you're going to look at your governing documents. You look at your bylaws. If there's no method of determining what the number is, then the answer is probably going to be 5. You're probably talking 5 directors. Now, when I say there's a method for determining it, sometimes the bylaws will have language that says something along the lines of, 3 to 9 or 3 to 7 or 5 to 9 or something like that, as determined by the board or as determined by the membership. Those are key differences, because if a board gets to decide, then the board might want to change the size of the board. Maybe you have more interest this year. You normally would have a board of 5, but you want to actually seat 7 people. great. If the documents allow you to do that, the board could just vote and say, okay, we're going to expand the size of the board. We're going to go from, 5 to 7 because the documents allow us to do that. They give us a range, 3 to 9, as long as, again, as determined by the board or something like that. You do want to look, because sometimes there's language that says as determined by your membership, and that's a different analysis. Then the board wouldn't be able to change the size on its own. That would now have to go to the members for a vote to change that size. We also were just going to recommend, often it'll say an even number, but sometimes it doesn't, but we're going to recommend to you, you probably want an odd number, not an even number, because you don't want to be split when you're taking votes. We don't want it to end up, in a 2-2 battle every time, and you can't get any work done. You can't make any decisions. So odd number, it should specify that. It might not, but that's what we're going to recommend to you. And again, look at your documents, see what that number is going to be, and check with your attorneys if you're not sure. Because again, sometimes we've gone through communities where they say, well, we've always just had 5 directors. Well, your documents actually require 7. So that could change things. Maybe you should be 7 with 2 vacancies, or have you been functioning with just 5 and using a quorum of 3 as opposed to using a quorum of 4 if you're really supposed to be 7. So that can make a difference. Those are all things to consider when we're talking about the number of directors. Now, getting into the terms, that's the next slide, if you guys don't mind. Typically, the term for your directors is going to be a year. Most terms are going to be a year. There is language, or there is the authority for you to have more than a year-long term if you have the language in your governing documents. So that's, again, key. We're going to check our governing documents. You could have a staggered board where, and that's the term we all use, where half the board is elected, maybe this year, and they stay on for 2 years. The other half gets elected next year. They stay on for 2 years. And you end up, sort of with this nice consistency of at least having some of the same people on the board. So the board can, again, have that consistent presence, maybe makes it easier to do some projects. You have people that have some knowledge and history while they're, coordinating with the new people potentially. You could have it up to 3 years. We've seen staggered boards where they do 3-year terms, and maybe you're electing only 1 or 2 directors each year. But all of that would have to be outlined in your governing documents. Otherwise, typically, again, the more standard, more average finding is most of the terms are just a year. Now, interesting little caveat to keep in mind. They changed the statute some years ago in 2018, and it was very confusing, and they changed it a couple different times before they really, nailed down what they were going to do. But ultimately, now, for condos only, condominium board members cannot serve more than 8 consecutive years, unless approved by 2/3 of those who vote in that election, or if not enough people run in that same election, which makes sense. If we don't have more candidates, why would we not want to keep someone on a board when we need to fill that seat anyway? The 2/3 of those who are voting is another way to stay on the board past that 8 years. But this 8-year thing has been a little confusing because, again, they put it in the statute in 2018. We all at first didn't know how that was going to be interpreted, what that meant. Does that mean for those people who have been on the board already for 10 years that they were automatically, unseated essentially? But no, we got some clarification from the division that it is going to end up being essentially 8 years from that 2018 deadline, or from that 2018 change. So our deadline is going to be in 2026, which now we're actually, funny that we're already here, but now this is something we have to talk about and something we have to think about. If you've been on the board for that long and your election is next year, what does that mean? You may need to talk to your council to see if this is something where you want to make sure you get at least 2/3 of the vote. When is your election? Is it before the, July 1st of next year? Is it after July 1st of next year? Does your term end in the middle of the term? The thinking seems to be, at least what we're hearing from the division and from some others, that ultimately, as long as you're elected before that deadline, before January 1st of 2026, you should be able to finish out your term. And then we're going to look into the next election. Were there enough candidates? Have you, or did you get 2/3 of the vote if you want to stay on the board past that 8 years? But again, that's a little complicated. It's up in the air. We're not sure how it's going to be really enforced by the division. So talk to your council if that's something that potentially impacts you or impacts your community. So it's condos only, and it's an 8-year term limit now. And again, now we're coming up against that because it's 2026 that's going to sort of kick in for everybody. Another thing to keep in mind, if the number of vacancies equals or exceeds the number of candidates, you're not going to have an election. That actually does make sense. If you have 5 candidates and only 5 seats, great. We don't have to go through the whole rigmarole of an actual, tallying and all of that. We can just seat those 5 people because we only had 5 candidates and we have 5 seats. Good news. So that's a nice, easy thing that's in the statute, nice and clear. It does sort of affect maybe how you're going to do your notice because, and we'll get into notices in a minute, but that's something that is nice and clear in the statute. You don't have to fully have the election if you have the same number of candidates or fewer candidates than you do seats. Board member eligibility, that's that next slide.
Mm-hmm.
The governing documents can require that board members, and again, we're in condo world, guys. This is a condo specific provision, then we'll talk about HOAs later. Your governing documents can require that the board members be unit owners. That is not automatic though. That's not in the statute. That has to be in your governing documents. We see this a lot. We get boards or managers who say, well, so-and-so can't run because they're not an owner, right? That's not an automatic answer. I have to look at your documents. I can't tell you that that's the case without checking your governing documents. The statute doesn't require that. Now, you may say, well, that seems silly. Of course, it should just be owners. Well, but when you really sort of expand how we think about it, you may have a husband and wife who live there, who have lived there for 20 years. And for whatever reason, maybe just the husband's name is on the unit, but the wife wants to run for the board, or vice versa. Wife's name is on title, husband wants to run for the board. When you say it like that and you explain it that way, then it seems to make more sense. Oh, okay, sure. I would love wife to be on the board. She's, essentially she's an owner, right? Well, she's not a record title owner in that scenario potentially, but if you want her to be on the board, that's fine, as long as you don't have that restriction in your governing documents. So again, you're gonna have to look at your governing documents. If you want to require that only unit owners serve on the board, only record title holders serve on the board, that's not in the statute. That would be something you'd have to put in your governing documents. For a trust, if a unit is owned by a trust, interesting little, twist here. Actually, Chapter 617 of Florida statutes addresses that and says that the grantor of the trust or the beneficiary who resides in the unit is eligible to serve and basically is considered the unit owner for that purpose. And then the trustee is also eligible to serve. So if you have, maybe if you're one of those 55 and better communities, maybe you do have a lot of properties that are owned by trusts, units, or lots, and this analysis would come into play. So if it's the grantor of the trust or the beneficiary who resides at the unit or the trustee, they are eligible to serve. They're considered the unit owner for purposes of board eligibility. If you have other requirements in your governing documents, they are not going to be valid. They are not going to be enforceable. If you have one of those provisions that says something, sometimes we see some older language like must be a permanent resident, must occupy the property, essentially can't be a snowbird to be on the board. That's not going to be enforceable. We're not going to be able to require that. We also get that question all the time. Can you put something in our documents that says that the board member has to live here? We don't want, investors to be on our board, or we don't want snowbirds on our board, or, all of these things that we hear all the time. That's not going to fly. So those are the requirements, and that's sort of what you get under the statute. The next thing here, next slide, there is one change that happened a couple years ago, and they sort of tweaked the eligibility in terms of delinquent owners. Now, again, we're in condo world when I'm saying this. A person who's delinquent in the payment of any assessment due to the association is not eligible to be a candidate. Now, two things to take away from this. It is an assessment. So previously it said any monetary obligation. which could have been a late fee, could have been a fine, could have been some sort of other charge that you have on the ledger, maybe you know, a boat slip fee or something like that. Any of those things before, if they had been outstanding, would keep you from being eligible to serve on the board. Now the statute changed a couple years ago that it is assessment only. So if you have an outstanding assessment, you cannot be eligible. You're not eligible to run for the board. You cannot be put on the ballot. So fines and fees, all of that, that still lets you be eligible. It's going to be different in HOA land. So, you know, again, we're talking condo only right now. A person who's been convicted of a felony or convicted of an offense in another state that's essentially comparable to a felony here is not going to be eligible for board membership unless their civil rights have been restored for at least 5 years. I know that's a strange one, and you're going to tell me, you know, how in the world would we ever know that? And I'm with you. Odds are you probably wouldn't know that. Sometimes you might, if you have some sort of sale lease approval and you ran a background check and maybe you do know something about the background of your candidates, but odds are you probably don't know that. I know, again, we hear this all the time. Do we have to run background checks when we put out our, you know, our notice for our annual meeting and tell people they want to get candidates? No, I wouldn't suggest doing that. But again, this is something that might come up because you may have some information from doing a prior background check. If they've had their rights restored for at least 5 years, then it's fair game. They're eligible again. Another sort of little thing to keep in mind, if you're in a condominium association with more than 10 units, so most of them, co-owners may not serve together. Now, there are exceptions. So co-owners, so a husband and wife potentially, that's usually the most common combo we see, cannot serve as members of the board at the same time unless they own more than one unit, or again, we didn't have enough eligible candidates. When you think it through, that makes sense. If we don't have enough eligible candidates and people want to serve, let's let them serve. If you do have enough candidates, then the only way they'd be able to serve together is if they own more than one unit. Again, that makes a little bit of sense when you think it through, because, you know, if you kind of think of unit A as maybe husband's unit and unit B as wife's unit, even if their names are on both, it does seem that any other owner who owns a unit would be eligible. So why shouldn't they be able to, you know, each run? Now, the other thing to keep in mind is that means they can serve together. Now, again, in most cases, they're not going to be able to serve together unless they own the 2 units or unless nobody else runs. If we're in one of those scenarios where that's not the case and they only own the 1 unit and we have multiple candidates, they could still run for the board together. So that creates a little bit of a challenge. That means they both wouldn't be eligible to serve together, but they could still both run for the board. And maybe it is one of those where the husband and wife say, well, we're both going to run, and whichever one of us gets the most votes will stay, and the other one will, withdraw their candidacy or whatever. Who knows? All right. Now, eligible person. What we've been talking about for the last couple of minutes is candidate eligibility. A key thing to keep in mind is you have to be eligible. The candidate has to be eligible at the time they submit their written notice of intent to be a candidate. The last opportunity to submit your notice of intent in the world of condominiums is 40 days prior to the date of the election. That's the deadline for those notices of intent to be received by the board. That's the time where they have to be eligible. They have to be current, as we just said, and then they can't be a felon. They can't, all of those other things. That's the deadline we're looking at. That's the time frame. So this gets tricky because when we talk about an assessment being due, you might have some sort of complications in terms of, well, our assessments are due on the 1st. That notice of intent deadline was the 2nd, but it's not late until the 10th. Does that mean they were delinquent? Does that mean they're not delinquent? That can get very complicated. That's a complicated analysis that's really going to depend on your governing documents again. So that's something where you really want to talk to your attorneys before you just tell someone they're not going to be eligible and that they can't run for the board. We want to make sure we do that analysis properly. If someone is ultimately put on the ballot that shouldn't be because they were not eligible, this causes a big problem for your election. Any ineligible candidates that are on the ballot jeopardize the entire election. The Florida Administrative Code essentially says, and again, we're still in condo world, guys, so the administrative code is very important. Florida statutes, chapter 718, addresses all of the condominium, laws, but the Florida Administrative Code also chimes in when we're talking about elections. So the Florida Administrative Code says that if the ballot includes the name of an eligible person, the association has to basically mail, transmit, deliver an amended second notice and provide a revised ballot to all of the owners. So essentially, if you sort of goof and you didn't realize that somebody was delinquent and you put them on the ballot, and then you realize before the election, you're going to have to renotice that ballot or renotice the elections and a revised second notice with a new ballot that removes that person's name with an explanation on why you're sending a revised second notice to remove an ineligible candidate or whatever it is. Now, again, you still have deadlines for when that second notice needs to go out. So if you don't have enough time, if there's not a 14-day period before you can send that amended second notice, now you're going to have to push your election back. So you're going to have to do it from that second notice, but you reschedule the election, you push it back so that you give at least a 14-day notice, and you send your second notice revised, correcting that error in the ballot. If your election has occurred, if you didn't realize that somebody was included on the ballot that was not supposed to be, that was not eligible to serve or not eligible to be a candidate, and your election has happened, guess what? This is why we said it's a big deal. Your election's actually deemed void. And now the association has to renotice and essentially try all over again. Really from that second notice again, though. You're not going all the way back to the beginning, but from that second notice, you're going to have to redo it. So it is a big potential penalty. So getting into the notice and the deadlines, again, we're in condominium world here. The notice provision, the deadlines provisions, very strict. We have to follow this procedure. It's very regimented. If you don't follow it sort of to the T, potentially you might be doing everything all over again. So no less than 60 days before your scheduled election, your first notice has to go out. The association has to mail, deliver, electronically transmit a first notice that includes the date of the election. Now, if you have owners it also has to include information about the deadline to consent to electronic voting, if the board authorized online voting, and we'll get into online voting in a little bit. Any candidate, and I already covered this, but we'll say it again, anyone who wants to run for the board, any candidate must submit their notice of intent, and it has to be a written notice to the association, not less than 40 days before that scheduled election. The owners have to ensure proof of delivery. It's not on the association. If there's anything other than hand delivery, the association really should be giving a receipt of that notice of intent. The association also can receive, in addition to those notices of intent, there's another deadline. So 40 days before for that notice of intent, there's a 35-day before annual meeting notice of or deadline for information sheets. So candidates can tell the board, I want to run, and then the candidate has 5 more days to basically put together a resume, a CV, or just a whatever else they want to call it. But it's essentially an information sheet. And there's a limit. They can't submit, a whole novel on why they want to run for the board. It's 1 page, 8.5 by 11. And again, deadline is 35 days before. And if that's given to the board, that's going to be included in that second mailing. And again, typically it's, this is why I want to run for the board. I've lived here for 20 years. I'm an accountant. I think I could be really helpful, whatever else they might come up with. Now we hear all the time, and I'll give you guys some sort of gossip while we're going through some of the stuff. We do hear complaints about people submitting information sheets that maybe are not the nicest. We'll say it that way, where they say, hey, I want to run for the board because the current board is doing a terrible job and I hate them and I hate everything that's happening. Now, I'm being dramatic, obviously, for the sake of the story, but ultimately, if that happens, the board can't just say, well, this information sheet isn't really an information sheet. It's, it's just a bunch of slander and defamation, and we're not going to include it in the package. No, the information sheet, if it's submitted by the candidates and it's submitted by the deadline, the board can't modify it. The board can't edit it. The board can't, leave it out of the package. It has to go with the mailing, and it goes with the second mailing. And And again, if they say bad things about the board, there might be another penalty for that, but ultimately you don't get to just leave it out. All right. Last notice is again the second notice, and it's 14 days prior to the annual meeting. That's the big one because that's going to go with the ballot and with the information sheets and all of the good stuff. That's your big package here. Has to go again, like I said, no later than 14 days. And the ballot is in there. Your 2 envelopes are also going to be in there. The ballot has to list all your candidates alphabetically by surname. Keep that in mind because you want to make sure your ballot is done properly. And that notice also has to be posted on the association property, on the condo property. We're in condo world, no less than 14 days prior to the date of the annual meeting. All right. Those are our deadlines. Now, important when we're talking about about notices as well is now we have website requirements, right? Everybody, hopefully this is not new to you. If you are in a condo of 150 or more units, this applies to you now. It's going to apply to almost everybody because 25 or more units as of January 1st of 2026, you have to have a website. One of the sort of catches, so to speak, of this website situation is you have to also post your notices there. The notice of any unit owner meeting, and this is going to include your annual meeting, must be on that website, must be very obvious, must be either just posted sort of on that home page, on the front of the page of the website, or on a separate subpage that's labeled notices. We want to make it nice and easy and dummy proof so people can find the notice. They can easily see it. Okay. Now, electronic notices, when we're getting into electronic notices, those are sent to your owners who have consented in writing to receive electronic notices. So this gets a little confusing for managers or for boards sometimes where they say, well, we have everybody's email, so we just send email blasts all the time. Okay, this is important. Pay attention for this point. Just because you have someone's email address does not mean they have consented to receiving electronic notices. You need to actually have electronic notice consent, something in writing where they said they want to receive notices by electronic consent. And then you can send them these notices by email. Now, ultimately, again, can you also send out an email blast? Sure. But if you're doing it in lieu of the mailing, you need to make sure they've actually consented to electronic notices. Now, the other part of that is any email address that's provided by an owner to fulfill a notice requirement is now subject to inspection when we do official records requests. So that may be why someone says to you, I don't want official notices to come to me versus, via electronic notices because I don't want my email address out there. I don't want people to possibly be able to get it and start sending me email blasts and all of that. I prefer old school hard copy notices. You can keep me on your list for, courtesy blasts, but I don't want to do the electronic notices. I don't want to sign a consent form. So that's important. You have to keep in mind your owners actually do have to consent to that in order to use electronic notices. Quorum requirement. When we're talking about your elections, this is also kind of a fun point. There's no membership quorum requirement for your annual meeting when we are talking about condominiums. There is no quorum requirement to have your election. Your annual meeting has a quorum requirement. To have any meeting where the board where your members are going to be voting, then you would have to have quorum. If you're presenting a vote to, waive non-SERS reserves, or you're presenting a vote on amendments or something like that, for your members to vote, to have the meeting, to pursue, the actual meeting portion of it, you would need quorum. Now, for the election, you do not need quorum. It is a different standard. For your election, the statute says you only need to have 20% of the eligible votes or eligible voters to cast a ballot in order to have a valid election. Those are very different numbers, obviously. Hitting quorum can be very, very challenging, especially if it's, a majority of your community, but getting 20%, that's much easier. So luckily the legislature gave us that in the world of condominiums. We only need 20% to cast ballots, and then we can have our election. So oftentimes in the world of condominiums, the annual meeting sort of starts with me announcing that we're here for the annual meeting. We don't have quorum. We can't really proceed with the meeting. We're not going to go through committee reports. We're not going to go through, manager reports, any of that stuff. but we can still proceed with the election as long as we have enough ballots. And again, the ballots that are returned at that point, those are the ones that went out with the second notice, and they are in 2 envelopes. There's an inner envelope so that you keep the anonymity of your vote, and there's an outer envelope. That outer envelope has a spot for a signature, a spot for a unit number, and that's how you verify who voted and make sure that everyone only cast one ballot per unit. Now, this is a funky change that happened just this year, so I need you guys to really listen up because this is a weird one. House Bill 913, that was the big bill that went through this year, and it's sort of causing some headaches in our field of practice here. House Bill 913 had a couple changes in it. First things first, it says for your annual meeting, if you're hosting your meeting via video conferencing, a quorum of the board has to be physically present, has to be in the physical location of your annual meeting. That is a very strange requirement because, like we said, typically you don't even need quorum of your members. So I don't know why you'd need quorum of your board, and I don't know why you'd need the quorum of the board to be there physically in person. It kind of doesn't really make any sense, but this is something to be aware of. And that's only in the case of if you're hosting your meeting with video conferencing. If you're not, if you're just hosting it in person, then you're fine. You can do it the way you've been doing it. You don't have to worry about a quorum of the board actually physically being there. If you are doing a video conferenced annual meeting, and video conferencing was added into the statute with an actual definition where it says real-time audio, real-time video. If that's how you're doing your annual meeting, you're a quorum of your board. This is just condo. I saw somebody's comment. This is only condo. A quorum of your board has to physically be present. Again, very strange new change to the law. So everyone needs to be aware because that's brand new. Okay. Now, as a practical matter, we don't know what will happen if a quorum of your board isn't physically there. In our opinion, the election would still go forward if you have enough ballots, because why wouldn't it? That seems silly. It would be, we're thinking of it sort of comparable to if a quorum of your members aren't there, we still proceed with the election. So to us, your election would still go forward, but again, not entirely sure how that's going to play out if there are any challenges down the road, since this is brand new and it's a very weird requirement. Now, the other part of this that went into House Bill 913, again, there were some funky provisions in here, guys. Now they say, again, you can host your meetings via video conferencing. The other part of that is anytime you have a video conference meeting, the notice has to reflect a hyperlink. So video conference means audio and visual real-time, conferencing. So any of the Zooms, any of the, Teams apps, that kind of thing, when you're showing video and you have real-time audio and video, that's a video conference. And now we have certain requirements when your notice is going to have video conference information. You have to have the hyperlink. You have to have a call-in conference number. So not just the hyperlink, but a call-in telephone number, because we do have unit owners who often can't, figure out the Zoom or the Teams. I won't point out the irony of that right now. That's fine. You guys all know. The notice also has to have a physical location. This is another change, or at least a clarification, I suppose. If you are hosting your meeting by video conferencing, there has to be a physical location. So it can't just be via Zoom, via Teams, via whatever. You have to have a physical location too. You can still have all of your people attend via Zoom. You maybe just have your manager sitting in the lobby with their laptop, by themselves, but at least you have to be able to say, also the meeting can be, you can participate in the meeting if you come to the lobby, because again, we want to make sure our owners are all able to participate if they want to. The other part of this is any video conferenced meeting also has to be recorded. That's another change. So if you're hosting these meetings via Zoom or Teams or any of that, you have to record that meeting, and that recording has to be kept in the official records and has to be also posted on the website for at least a year. So these things now we've kind of, if we're in video conferencing world, check with your attorneys, make sure you're doing everything the right way, because now we have some new requirements, okay? All right. First step when you get to the annual meeting. Like I said, the package that went out, the second notice package, had the ballots and it had 2 sets of envelopes, the inner envelope, the outer envelope. First step is essentially verifying you get a committee, you get some volunteers to help you verify these envelopes and start the whole process. So it's not going to be your board members. They're not doing it. You're not going to have, I wouldn't suggest necessarily having your management team do it, although sometimes you don't get volunteers and they need to help. But first, you're just going to have an impartial committee do this work, essentially. When I say impartial committee, the Florida Administrative Code actually says that it can't be anybody who's on the board, any candidates, any officers, or any of their spouses, none of the current members, nobody who's running for the board. That makes sense. We want them to be objective people who don't really have, a dog in the fight, so to speak. You could actually have an impartial committee meeting prior to your annual meeting. It has to be the same day, and it has to be noticed. It has to be open to your owners. But that's a good idea. If you're in one of those communities and, your election last year took, 5 hours because you had so many people vote and so many ballots to confirm or to verify and ballots to tally and all of that. If your meeting takes that long, maybe you want to do it in 2 steps. That's very helpful. We've had a community that was once there until, 1 a.m. and they learned their lesson very quickly. We don't want to be at another meeting till 1 a.m. So we're going to do it this way. We're going to do it in a 2-step process. You can do that. You have a meeting, you host it, earlier in the day. The board has already basically picked their impartial committee members. You notice it like a committee meeting, same day. Again, it's open to all the owners. If people want to come watch and make sure the ballots or the envelopes are being properly verified, they can do that. And all you're doing at that committee meeting is verifying the envelopes. You are not opening anything yet. You are not looking at any ballots yet. You're just verifying the outer envelope. You're looking at, the list of voters and you're making sure, yep, Mr. Smith owns unit 101. Perfect. This is Mr. Smith's ballot or envelope and he has a signature on it. I can cross that off. Great. We have 1 ballot from Mr. Smith. Moving on. Once you get all those ballots, first step, like I said, you verify all of the envelopes. Now, let's say we've done that, and whether you did it in 2 steps or not, when we actually get to the election, the first thing, collect all your ballots. If you have anybody else who shows up and wants to come vote in person, maybe they lost their ballot, they show up and say, hey, I don't have an envelope. Can you help me out? Give everyone a few minutes to get sort of settled. You collect the envelopes, you collect all of those envelopes, and now we verify all the outer envelopes. Then we open all of the outer envelopes. The polls are closed and we can't open any more or we can't take any more ballots once the first envelope is opened. So this is why I said, if you do it with that committee meeting earlier in the day, make sure your committee members know they are not opening any envelopes at that meeting. It's when we're actually at our election and we've verified all of the outer envelopes, then we start the process of opening. And once we open that first envelope, we can't take any more ballots. And that is a hard and fast rule. So if someone runs in, 30 minutes late and you're tallying and they say, well, let me vote because I have an envelope here. Well, it might just be too late. If that ballot, if there's an envelope that has more than 1 ballot, or if there's something wrong with that envelope, you're going to put it aside, you write disregard on it, and you still hold on to it. Everything ultimately is going to be kept by the association. All of those records, or all of that's going to be in the records. It would be open to inspection for any of your owners. If you have a tie, that comes up very often in condos, oddly enough, then the Florida Administrative Code actually outlines a process for a runoff. Often, if that comes up, once you announce sort of, hey, the last, our last 2 vote getters have both got, 30 votes and it's John Smith and Mary Jones. Guys, what do you want to do? Oftentimes, one of them will say, she can have it. I'll step down. It's fine. Let Mary be on the board. I'll take a step back. Don't worry about it. But if they're both hardcore, well, let's do it. I want to run for my spot. There is actually a procedure and you have a runoff and it's basically like almost having a mini election. But there is a deadline. You do a new mailing. It has to be held within 21 days, not more than 30 days, all of that. All right. So that actually is in the administrative code as well. Now, another new law as part of House Bill 913 was this electronic ballot. This is another weird one, so I have to kind of spend a minute to explain this to you. Now, and there are 2 different ways to think of electronic voting. This is different. This is an email ballot. This is brand new. Essentially, if the association does not currently allow for electronic voting, which they may want to consider after this change. If you don't have electronic voting, the association has to designate an email address to receive electronically transmitted ballots. So essentially, if you don't already have a third-party platform where you can do the online voting, electronic voting, now you have to designate an email address to receive email ballots. So this is, again, a little strange, guys. A unit owner can electronically transmit their ballot to that email address. And for it to be valid, it just has to comply with certain requirements. It has to go to that email address no later than the date and time of that election. And there isn't much that the ballot has to contain in order for it to be valid. It has to have a spot for their unit number. It has to have a spot for their name where they type in their name. Their name is essentially considered their signature. And then it has to have a disclaimer. And this disclaimer, I will read it to you because it is very strange. And my English teacher, I'm sure my English professor would be rolling over in her grave if she heard it, but I will read it to you. This disclaimer has to be in a big, bold font size and all of that. And it has to be on this email ballot in order for the email ballot to be valid and to be counted. And here we go. It says, waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy, but wish to participate in the vote that is the subject of this ballot, please attend the in-person meeting during which the matter is being voted on. Whew. So, a lot of secrecy words thrown in there. The gist is, in case you didn't gather what I just said, the gist is you're sending an email, so your ballot is no longer anonymous. Everyone's going to know how you voted, or everyone can know how you voted, I suppose, because it's in the records, and if anyone wants to look, they can find out. Typically, the way we said in the traditional sense of condominiums, typically your vote is anonymous. That's the purpose of having those two ballot envelopes. Or you have the inner envelope where you put your ballot, and you have the outer envelope. And once we take the inner envelope out of the outer envelope, then your ballot is completely anonymous and nobody knows how you voted. Here, this is why they have this lovely disclaimer now. Ultimately, your ballot's not going to be a secret if you vote this way. And again, it's an email ballot, so it's a very strange way to do it. You're basically, and the legislature told us they want the owners to be able to easily send an email without having to go through all the rigmarole. We have so many owners who are out of state, who are international, and they don't get the mailing in time. They don't get the ballots in time. So if you don't have electronic voting, this is something you may have to contend with. This may be something that comes up in your election this year. Now we'll move into HOAs. All right, HOA world. This is different because you guys are not regimented the same way condos are. The big thing here is your governing documents are going to control how you do your election. Your governing documents are going to be the key for everything. You could amend your governing documents. You could make your governing documents kind of give you a procedure more like the condo if you wanted to, but it might not be. So look at your governing documents, talk to your attorney. The eligibility requirements are also a little different. We don't have the 8-year term limit. There's no term limit situation here. If you're convicted of a felony for at least 5 years, that requirement is still there. And here's another slight difference, but could be important. If you're delinquent in the payment of any monetary obligation, not assessment, monetary obligation, you're not eligible to be a candidate. So that means a fine or anything else could stop you from being able to run for the board. Any pending charges of felony theft or embezzlement, that's going to keep you from being able to run. I'm perfectly fine with that. That sounds great. Any offense involving association funds, obviously, then we wouldn't want you on the board if we think you might have committed a crime involving association funds. So that makes sense. Co-owners are permitted to be candidates. So we don't have that restriction here. You could have a husband and wife that are on the board together. They wouldn't necessarily have to own 2 homes. They could both just serve. Those are your eligibility requirements here. Now, the association has to hold their annual meeting at the date and time that's listed in their bylaws. So look at your bylaws. Your election is going to happen at that annual meeting. Your notice has to provide the date, time, location of the meeting. Look at your bylaws. If they don't provide any information about giving notice, it's going to be a 14-day provision. So it's very different. Condos, again, have multiple notices, have very strict deadlines. HOA, it's one notice, not less than 14 days before the meeting. Again, any of these notices, you're also going to have an affidavit to basically demonstrate that you did the mailing properly. Here, again, and you keep those affidavits in the official records. So it's one notice, and you have the same requirement in terms of owners have to consent in writing if they want electronic notices. Same thing here. All right. This is our big warning, Will Robinson. So you have to look at your governing documents when we're talking HOA elections. Very different. Every community might be a little different on how they do their elections. Typically, the associations are actually required to take nominations from the floor. So a 14-day notice goes out and we have the meeting and we don't even know really what's going to happen. We don't know who's going to run. We don't know if the same board members want to stay on the board. We don't know if we're even going to have an election. So HOA world, we kind of joke that their annual meetings and their elections are a little bit of like the wild, wild west. You just don't know what you're going to get. If you prefer to have a more regimented, regulated election process, if you want to do written notices of intent and all of that, and you want to be more like a condo, again, you could amend your governing documents. You could make it so. Otherwise, you're probably doing it like this. You're probably going to open up your meeting at your annual meeting and say, okay, do we have any nominations from the floor? If you have a procedure already in your governing documents to allow for nominations to be taken in advance, maybe you do, maybe there's something in there, maybe there's a nominating committee, then that's okay and you don't have to take the nominations from the floor. But odds are most of them you're taking nominations from the floor. And even if you have a nominating committee, make sure they're operating in a certain way. If the nominating committee is taking any interest and they then list that candidate, great. If you have one of those nominating committee provisions that's written a little strangely where they specifically only pick, their favorite 5 people to run for the 5 seats, then that's different. Now we would have to allow nominations from the floor because you didn't let, every owner just put their hat and throw their hat in the ring. That's the key. So nominations probably taken from the floor. All right. Also a big difference. This is probably the biggest difference. Quorum has to actually be established in the world of HOAs because you're not having your election unless you have your annual meeting. So if you can't reach quorum, which we did get the sort of gift that at least in HOA land, quorum is only 30% of your total voting interest, or a lower number if you have a lower number in your bylaws. So again, maybe consider looking at your bylaws, maybe doing some amendments. If you have a lower number, you go with the lower number. Default is going to be 30%. So 30%, let's assume, you have to hit that in order to even open your meeting. So first step is going to be to check everybody in, to check in proxies. Let's see if we have quorum, all of that. If you don't, and that happens all the time, and we hear it, we hear it every day where someone says, my community hasn't had an election in 15 years. Well, this is probably why. They probably never hit quorum. They probably can't proceed with the annual meeting. So I've been to many meetings where, I get there, I help supervise checking people in and getting proxies and all of that. And we do a head count and we're nowhere near 30%. And even if we give them some time, no one's coming. We don't have 30%. So then essentially I have to announce to the room, thank you guys for coming out. So glad you were interested, but we didn't hit our quorum number. So we are not going to proceed with the annual meeting and we are not going to proceed with any election. And ultimately your current board rolls over and stays the board. So that's a big difference. All right, because we need to hit quorum in that case. And if you don't hit quorum, you don't have a meeting. If you don't have a meeting, you don't have your election. So again, that's why sometimes, again, communities will want to do something more like a condo where they can maybe do some advance notices, things like that. All right. Now at your election, if we're talking, again, HOAs, members have the right to vote in person or by proxy generally. You look at your governing documents, make sure that's the case. Your governing documents don't have any special language there, but generally you can vote in person or by proxy. And that's where we'll see, again, in some of these communities where they say we haven't had an election in, a million years, it will take some owners going around, knocking on doors, gathering proxies, telling their neighbors, hey, I know our meeting is, in the middle of holiday time. I know you're going to be out of town. Please give me a proxy and I'll vote for you. And at least it'll count for your quorum, whatever it is. And we've seen owners walk in holding, 40 proxies and basically saying, okay, I represent 40 plus myself. So 41 lot owners. So 41 of our owners are here tonight just by proxy and, by the virtue of this one owner walking in with a stack of proxies. That's usually the way we get to our quorum number and we can get the election going. Now, again, there could be another procedure in your documents. You could have something more like a condo where they do a secret ballot, they do some sort of absentee ballot. Look at your governing documents, see if that's the case. Otherwise, if we at least hit quorum, we open up the floor. We ask if we have any candidates. We give every candidate, 3 minutes to introduce themselves, let everybody know why they're running, who they are. Then we hand out ballots, and everyone who's there gets to vote. And if you were that unit owner who walked in with 40 proxies, you're going to get either 41 ballots or you're going to get, a ballot that then also says, times 41, so that you get to represent all of those proxies that, or, you're the proxy holder for 40 of your neighbors. You get to vote 40 times plus your own vote. So 41. Oftentimes that's then the person who probably carries the election and they're the ones who probably end up on the board. But that's how, if you're in the world of HOAs, if you're saying you don't have election, you don't know why this is the same board over and over and over again, that's how you can sort of change things and get some momentum. That's really what you're going to need to do. Now, ballots, proxies, that's all tabulated at the same time. Then we announce the results. There we are. Now, what if we have vacancies on the board? And this is for both condos and HOAs. How does that work? Well, look at your bylaws, and I'm sorry I sound like a broken record, but look at your bylaws. If there's no provision in there about how to fill the vacancy, the rest of the board gets to decide who fills that vacancy. Now, fun little fact here. I'm a trivia nerd. This is the only time the board could actually do something when they don't have a quorum. So if you hypothetically are one of those associations that only has 3 board members, and maybe one board member resigns and says, I have too much going on, I can't be on the board, sorry, see ya, and they resign. Board member number 2 says, oh, I'm moving across the state, I'm resigning too. So you're left with one board member. Well, in a normal world, one board member can't do anything. You don't have quorum, they can't, they're stuck. So the one thing they can do without quorum is appoint someone else to the board, because now we're up to 2. Now we have quorum. Now those 2 board members could appoint a third, and now you're back up and running. You have a full board. Great. Alternatively, and sometimes this happens in some of these communities where we have a little contention, we'll say, maybe you are a split board. Maybe you're a board of 7 and somebody resigns and you are a 3-3 split. And, side A says, well, let's put, Mary on the board. I think she's a good candidate. And side B says, absolutely not. If you guys are the ones who suggested her, we're not approving her. So we want, Stan to be on the board. And then side A is going to say, well, we don't want Stan because you guys suggested him. So absolutely not. So you're stuck in this, 3-3 split, and you're not going to be able to get anything done because you're just divided so steadfast. The other option is you guys could say, well, let's let the people decide. Let's have a mini election to fill that one vacancy and fill that spot. Alternatively, if it's already sort of coming around to your annual meeting, you don't have to fill the spot. You could just let the annual meeting address it if it's about to come up anyway. So that's another option. If it's in a vacancy that's filled by recall, there's a different provision there. You'd look at your vacancy or look at the recall language and address it there, but that's a specific circumstance. We don't really have to get into it today. Electronic voting. So let's get into sort of the other option, not your email ballot, an electronic third-party platform, electronic voting. And now it seems like there's a million of them. Since COVID came around, a lot more companies have popped up. This has become much more popular. A lot of communities are actually using this now. They weren't necessarily before because maybe they were a little scared, the technology or the cost or whatever it was, but electronic voting has been in play for a while. Now, first step, if you want to do electronic voting with one of these third-party platforms, you have to keep in mind there are many requirements of how this is to be set up, how this is to be done, how this is to be run, which is why the board can't do it on their own. The association isn't going to be able to do it. You would need to hire essentially a third party to do it for you. But it is a platform, it is a system that has to comply with certain requirements. First step is the board would have to decide to do it. So the board would have to adopt a resolution that it wants to establish this online voting and to use this online voting platform. And for condominiums, the board can do that at a 48-hour noticed board meeting. It used to be 14 days and they changed it this year. So it's only 48 hours if you're a condo. It's still 14 days if you're in an HOA. So HOA has 14 days, to notice that board meeting. You adopt the resolution and you have to make sure the platform complies with all of the requirements. The online voting is going to make sure each owner essentially that their vote stays anonymous, that they register properly, all of that. It authenticates their identity. I authenticates the validity of their ballot, all of that. All of that is done through the platform. The ones that are around now, for the most part, they all know what they're doing. So just make sure you talk to council and hire the right people. And then all of that should be safeguarded and protected through their platform anyway. But the key is ultimately those online ballots, the nice part of the online voting is their votes all stay anonymous. You just know, you get a record that, John Smith from Unit 101 voted, Mary Jones from Unit 201 voted, but you don't know how they voted. And then you get a nice little tally at the end that says, that Bob got 23 votes, that Sally got 43 votes, and you don't know how John or Mary actually voted. It is a nice platform there. Now getting to your officers. So following the election and again, the election, generally your members are basically deciding who's going to be on your board, right? Your members have decided these are the people we want to serve us. These are our directors. They don't get to decide, but we really want Bob to be our president, or we really want, Mary to be our president. Your owners don't get to decide that. The board members get to decide that amongst themselves. So we typically call that the organizational meeting, or it's really just picking the officers of the board. But usually that's done sort of in conjunction with your annual right after the election. It should be noticed that, because it's really a board meeting, that it's going to follow the annual meeting, and the board gets to decide amongst themselves. They can decide, hey, I want to run for president, or I nominate Mary for president. And then you do a little vote just amongst yourselves. So if you're a board of 5, only those 5 people are deciding who's going to be president, vice president, treasurer, secretary, not, your entire membership. Also, fun little trivia fact, this is the one time that directors get to vote by a secret ballot. So generally, directors aren't allowed to vote by proxy or by secret ballot. But here, when we're deciding who the officers are going to be, that's the one time they get to use a secret ballot. So again, like I said, trivia nerd here. The other thing to keep in mind, there's no prohibition on changing your officers midstream. So if you're 6 months in and you decide, hey, Bob's not doing a great job as the president, or maybe Mary's overwhelmed as the president and doesn't want to do it anymore, you guys at a regular noticed meeting, 48 hours, the board could decide to change the officer positions. So you could reorganize all of them, some of them, whatever it is, at any point in time. Last little thing we need to talk about is the board certification, because this is important. You guys now have new requirements for education and all of that. Board members now generally have to have a written certification that they read their governing documents and they're going to uphold them. And they have to attend a division approved education course. That used to be an or, now it's and. Now you have to do both of those things. That certification course for condominiums has to be at least 4 hours long, and it has to include certain topics. Obviously, we have one and it includes all of those things. And it is 4 hours, so I know it's long, but they made us do it, guys. It's not our fault. And board members have to be certified within 90 days of being elected or appointed to the board. If they are elected or appointed before last year, essentially, then they had until June 30th of this year to get it done. Now, you also have a new continuing education requirement. This is, again, we're talking condos. Each year, you have to take 1 hour of essentially continuing education related to the changes in the law. So again, those legal updates that you see all the time, now you guys as board members need to take those. The certification is going to be valid for 7 years after the date of issuance, as long as you serve on the board uninterrupted. You have to keep a copy of that certificate in the official records. HOA certification. So HOA certification, a little different, but not that different. 90 days, same thing, from between 90 days of being elected or appointed, you got to get that done. You have to, again, written acknowledgement that you've read the governing documents, and you have to take a course. The course, this one, they didn't actually say it has to be 4 hours. So you guys come ahead a little bit, because our course is, I think, really like 3 hours, but just gives you an extra little extra time. Now, director has to complete the education at least 4 years, every 4 years now. Another thing to keep in mind, now again, there's sort of this continuing education requirement, right? So if you are in a community that has 2,500 parcels or fewer, it's only 4 hours of continuing education each year. Although I say only, but 4 hours I know is a lot when you guys were, starting with 0, going to 4 is a bit of a burden. But if you're in a community that's much larger, 2,500 parcels or more, they have to do 8 hours each year. So I know, again, division decided our board members really need to be educated, and we need to make sure they're doing it. So now you guys have these lovely, in addition to your certification, continuing education requirements. The proof of certification, that needs to be held on to. The board needs to have that in the official records for at least 5 years. It's valid for up to 4 years. If you don't timely file your certificate, technically you're suspended from the board. So make sure you're doing what you need to be doing, and you get that done. The board can actually temporarily fill that vacancy as well and treat it as a real vacancy. All of this, well, we're a little over time, but one more quick point. When we get to records and disputes, when we're talking about keeping all of your certificates, that brings us to records here. Time frame, if you're going to challenge an election, is 60 days after the results are announced. So if you think something wasn't done properly, you think the election wasn't conducted properly, if you're a unit owner who wants to, present a challenge, you have 60 days from the time the election, the results are announced. So the election night, typically. Any of these official records, ballots, sign-in sheets, all the proxies, anything else that relates to a vote has to be maintained for at least 1 year from the date of the election. So that's in the official records. So again, if you have a question about what happened with your election, I would suggest step 1, maybe you want to go look at the official records, do a records request, and go through the documents. And again, all the owners who say, I want to see this, I want to see that at the election or at the annual meeting, we often tell them, hey, we are keeping all of this. This is all going to be in the official records. We're not hiding anything. You can make a request and you can come see it. The notices have to be kept for 7 years. So that is one difference. But all the ballots, the proxies, all of that, the envelopes, that's 1 year. And another little change that happened a couple of years ago. Now, when you're challenging it, it can go through the division, or you can file a petition for arbitration or an action in circuit court to challenge an election. Okay, I know we got through it all. It was a lot. I'm sorry we had some issues with the technology. Michael, did you have any questions that you think we should answer?
Yes. So got a few here. So let's see if we could get to them real quick. All right. Let's start with this one. If our governing documents require an election, do we need to have one if there are same number of persons for the number of seats? Does the statute absolve us from this requirement?
Right. So that was one of the things. I'm assuming you're a condo probably, but right. The way that would go is essentially you'd send out your first notice for the annual meeting, the election. In that first notice, you're telling all your owners, hey, there's a notice of intent deadline. If you want to run for the board, let us know by this deadline, 40 days before the annual. If that deadline comes and goes, and again, you have 5 seats and you only got five candidates, then great. Then your second notice goes out and just tells everybody, okay, at the annual meeting, we're just going to seat those 5 people. You don't actually have to send out new ballots. You don't have to send out envelopes. We're not tallying because you only have the same number as there are seats.
All right. The next one is, if an incumbent board member is not in compliance with the educational requirements in the statutes, are they eligible?
It's so interesting because the eligibility is a little tricky because they're very specific on what makes you eligible and what doesn't. Essentially, you could be eligible to run, you could be eligible to be a candidate and to have your name on the ballot, but you might not be eligible to serve. So, with the education requirement, that would be interesting. I wonder how that would play out. But those are different things. It might be something that politically you want to handle. You might want to tell them, hey, maybe you guys don't want to vote for Mary because she already didn't do her education, and that would be something you could handle more politically, but it doesn't say they're not eligible to run.
Gotcha.
Yeah.
If an individual is delinquent in special assessment fees and you don't have Kaufman language, can that person be prevented from running on the board?
I would say, right, if they're delinquent in the payment of an assessment, and I would still treat that as a special assessment too, then yes, I would say they're ineligible and you can't put them on the ballot. But
Okay.
again, we'd have to look at it. We'd have to look at the ledger and look at how that was all done. But my very brief reaction is you could probably keep them from running.
Gotcha. We'll do one or two more here. Can the board use consent from previous online voting platform on the new voting site?
Oh, interesting. So yes, typically the consent is an online voting, consent or electronic consent. The person would have to withdraw their consent if they no longer want to participate. So it should work for if you change platforms. I know sometimes the platforms really want to just see the board resolution. So you make sure you keep a copy of that board resolution where you adopted electronic voting. Yeah.
All right. And then what is the rule for HOAs that do their annual meeting via Zoom? Does the quorum of the board have to be physically present at the physical location?
No. So this is why it's a little funky, because they only added all that stuff to the condo statute. It's only in 718. 720, arguably, you could still do it totally via Zoom. It would be a little strange because, again, if you're in one of the more standard, typical HOAs, you're probably taking nominations from the floor. So you probably do need to have a physical presence, but in theory, no, there's no requirement that the board be there. There's no requirement that you have video conferencing and a physical location.
Okay, here's another one. Can a condo owner who is behind on his maintenance fees still turn in his or her proxy vote?
Well, if we're talking proxy, this is really involving, suspending the voting rights. That's something that talk to your counsel, because that gets a little complicated. You want to make sure you do that properly. You have to look at your governing documents. You also have to follow the procedure in the statute. There is a way to suspend voting rights. So potentially you would be able to say, Mr. Jones turned in a ballot, but Mr. Jones isn't actually, his voting rights are suspended, so we can't count his ballot. That could be possible, but again, talk to your counsel on how to do that properly.
Okay, if you are required to have a location for some who cannot use Zoom, do you have to have a supply visual such as a smart TV or a laptop also?
Well, if everyone else is basically attending via Zoom, then I would suggest, yes, you should have something so that they can, if they have the physical location, so that they can actually see what's going on too. So either, again, like I said, maybe the manager's just there with the laptop. That's fine. I don't think you need to have, fancy schmancy technology with, a broadcasting it on a huge screen, but you would need to be able to show them what's going on.
Okay. Do the bylaws need to be amended if they want electronic voting?
No, good question. So electronic voting, you can do the statute allows you to do it just as long as you follow those procedures. So you have to adopt a board resolution at a properly noticed board meeting. The resolution has to have certain language in it, and you have to make sure that your platform that you're using is going to be compliant. So that's really what you need to spell out. So talk to your attorneys about how to do that properly, but it does not mean you actually have to change anything in your bylaws. That's fine.
Okay. In a condo, the candidate was current with assessments at the time of their form was submitted in November. What happens if they miss a December 1st special assessment prior to the election night?
Also a good question. This is why this whole analysis gets a little complicated. So to run for the board, to be eligible for the board in the world of condos, you have to be eligible on that 40-day prior deadline to turn in your notice of intent. The little catch here is that's the time to be eligible. Now, if you fall behind between that deadline and the actual election, there's no penalty there. If you are seated on the board, if that same person is then seated on the board and they're running a balance, that is still okay as long as they don't become more than 90 days delinquent. So once you're seated on the board, they give you a little wiggle room to kind of fall behind. You have a little window to make sure you're current, and it's a 90-day window. So as long as you're not more than 90 days, you can still stay on the board. You can serve on the board. So there is a difference there. So you got to make sure, again, it's very technical, and you make sure you're looking at the right deadlines.
Okay. Are the educational requirements calendar year or fiscal year?
Also a good question. And just to kind of throw off your answer, most of them are really essentially from July 1st to June 30th, because they were sort of with the way the statute changed and when the division did it. Somebody just asked what happens if you don't get the 20% at a condo election. And that's a good question too. Typically you do. The 20% is usually pretty easy to hit, but then we would say same thing that would happen in the world of HOAs. If you don't hit your number, then the old board essentially rolls over. The board has the option. You could try and kind of continue it and reset it if you needed to, or if you wanted to, but otherwise we would say the old board just rolls over. You didn't get enough, and there you go.
Okay. Well, we'll wrap it up there. I know we're a little over time here. So I want to thank everyone for joining us today, and a big thank you to, of course, Emily for sharing her expertise. A few final reminders. So the evaluation form is required to receive your CU credit. That is in the comments section right now, so you can click that link. Certificates will be emailed 5 to 7 business days to you all. CAM credits will also be reported within 5 to 7 business days, and the recording will be shared, but again, cannot be used for a CEU credit. We'll send a follow-up email with the recording link, slides, and contact information.
Yes, you will get the slides, guys. Sorry about our problem here.
Thank you again, everyone. Have a great rest of your afternoon.
All right. Thank you, guys.
Bye, everyone.